Welcome to this EdVid on estate planning, specifically on reasons why to use a revocable living trust. A revocable living trust can be a main component of most effective life and estate plans. I am your host, Jeffrey G. Marsocci, an attorney licensed in North Carolina and author of books, white papers, and other educational resources on proper protection planning. Please note that this EdVid, or educational video, is being created by me and my law firm. While we reference and discuss a company called The Estate Plan, Henry W. Apps III, and Henry's book The Living Trust, this EdVid is not sponsored nor endorsed by them or anyone else. They are simply excellent resources we are happy to discuss. Also, please note that this is not a substitute for proper legal advice, and no attorney-client relationship exists between me, the host, and you, the audience member. If you have legal questions, please contact an experienced life and estate planning attorney in your state or jurisdiction. As an attorney, I have been working in my own firm in North Carolina since 1996, and I am authorized to practice in front of all courts. Well, that's all well and good, and it sounds nice, but I haven't been to court in almost 5 years, except for jury duty. Here's a copy of the check from the last time I was paid to go to court. There is a good reason I have not been to court in 5 years, and that is because my law practice is focused on preventing problems rather than cleaning them up afterwards. I have been working with the estate plan since 2000 and became more involved in 2005 when I joined their legal counsel to give advice to the company on new laws and tax regulations, as well as ideas on spreading the word about estate planning ahead in order to avoid court problems and expenses later. I also earned their Legal Master of Estate Preservation designation, which is really just a fancy title showing that I know what I'm talking about when it comes to life and estate planning. I have also been a lecturer at the Estate Plan's annual conference, the Advanced Institute, each year since 2006. In addition to being an attorney, I have managed to write several books on the right way to plan ahead using life and estate planning documents. I have written The Anti-Probate Revolution, Estate Planning for Married Couples, Estate Planning for Domestic Partners, The Joint Property Tax Trap, and The Gay Marriage Alternative to help all families and couples of whatever circumstance protect themselves and their loved ones. I am also the chairman and an instructor for the National Institute for Domestic Partner Estate Planning, an organization devoted to helping attorneys and other professionals help their domestic partner clients use proper partner protection planning the right way without hitting the common tax and other landmines out there. But I'm not going to go too deeply into that. There is enough material in that specific area to comprise a whole other EdVid. But enough about me. Seriously. I only went through all of that to assure you that I know what I'm talking about. If I didn't, you might think I'm just another hack lawyer trying to make money off other people's misery by abusing the legal system. Part of my job is helping my clients avoid the avoidable parts of the legal system if they have the foresight to plan ahead the right way. We'll talk about the other kind of lawyer later when we get into probate attorneys who recommend wills instead of living trusts for their clients. As I mentioned, I have been working with the estate plan for a number of years now, and I actually have to credit the founder of the company, Henry W. Apps III, with getting me started in this area of law. The summer before going away to law school, my grandfather died, and my grandmother, as all proud grandmothers do, Assume that I walked through the door, my head was opened up, and all of this legal knowledge was dumped into my brain, and I automatically became the perfect legal resource. Well, it didn't quite work like that, but I did my best to answer her questions. She kept asking me, why was this probate process taking so long? Why was it so expensive? And most of all, she kept asking, why is this happening? I thought we did everything right. Unfortunately, my usual response was, Granny, I don't know, but I'll look for the answer and I'll call you back. And no, I did not bill my grandmother for the research. I gave my grandmother all of the answers that I could find, and it basically looked like there was nothing that could be done at the time. But I started wondering how this all could have been avoided. The more I looked in the law school library, the more discouraged I became in figuring out how this mess could have been prevented in the first place. I actually went to a bookstore at the mall and found The Living Trust by Mr. Apps. Once I read it, I discovered a lot about the pitfalls of the probate system, the unnecessary costs and delays, and most importantly, a solution for avoiding the probate court process. I also read about how much money was being thrown at probate attorneys for needless work, to the tune of billions of dollars a year. It was almost like an annual government bailout for attorneys. It was then that I decided to make avoiding probate a major part of my law practice, to do the right thing rather than exploit the system by recommending wills which could lead to probate, which would definitely lead to probate. And so the Revocable Living Trust is at the center of many of the estate plans we recommend. Now for the heart of the presentation. What is estate planning? Basically, estate planning is the process of passing your property from one generation to the next. What becomes more important for my clients is how that is accomplished. My clients want their property to pass from one generation to the next without unnecessary costs, unnecessary delays, unnecessary potential contests of their plans, and without unnecessary loss of privacy. Unfortunately, the probate court process inherently has these problems built in. Because of this, many of my clients want to avoid the probate court process altogether, and a revocable living trust can help them avoid these problems. The next logical question is, what is probate? At least that's the logical question for most people. If you've been the executor or administrator of an estate, you know what the probate process is, and probably have the scars to prove it. Probate is a court bureaucracy that validates a will if you have one. It oversees the payment of your debts, including probate and legal fees, and then transfers property to the right people. The final and main point of probate is that it transfers title to assets to the right people. That's really it. Probate is an elaborate, expensive, time-consuming process to retitle the assets of a deceased person. Okay, probate wastes how much of my inheritance? All right, for those of you out there saying, isn't that just like an attorney to exploit his children to make a point? Let me assure you that he is not my child. I'm merely exploiting a friend's child to make my point. And the important point is that probate does take away a lot from inheritance. According to an AARP study and several other multi-state studies, probate consumes about 4 to 10% of a person's estate. Now, let me be clear for the married couples out there. This generally does not apply between a husband and a wife. These costs are usually incurred after the death of the second spouse when the assets are going to the next generation. And now to bash some of the members of my own profession. Probate attorneys are very happy to look you in the eye and tell you probate fees are not that high in our state. What they are saying is, compared to other states, the fees a court charges for probate are not that high. What they are leaving out is that their fees for administering the estate typically push the costs into that 4 to 10% range. What? A lawyer only telling half the truth? I never would have thought that was possible. Okay, let me also be clear on the lawyers out here. I have no problem with probate attorneys who help families navigate the court process. They charge a lot in fees, but they do the work, and most deserve every single penny. What I have a problem with are attorneys who tell their clients to get a will because probate is no big deal. In my opinion, they are giving false advice either in the hopes of getting much more in legal fees later, or because they genuinely don't know what they're talking about. They also may be a little blind to the agony people go through in the probate process. After all, some of these attorneys may also be doing complex business cases, long-term divorce cases, and these can be litigated for years and cost an awful lot of money. So, when they're, in their view, 6 to 18 months and between 4 and 10% of money that's being inherited anyway, it may not seem like all that much in comparison to the other cases that they're taking on. But the fact is, it really can have a toll on a family. And I just think they're a little disconnected from that. So be sure to be on your guard when you discuss wills and revocable living trusts with an attorney, and make sure that you're getting the numbers on how long it generally takes to handle probate. Speaking of which, the average time for probate is between 6 and 18 months in which assets can be frozen. It is common advice in my firm and in many others to give as little money as possible to the beneficiaries in the early months following the death of someone in order to make absolutely sure that there are no surprise debts, to make sure all of the beneficiaries sign off on the distributions, and to make sure all of the assets have been collected. Because the probate courts usually demand strict accounting of every penny and impose exacting processes for selling off assets, executors and their attorneys take a lot more time to follow these processes to the letter. With a revocable living trust, there is a lot more flexibility in settling the trust, so it takes a lot less time. In 2009 and now into 2010, our firm is assisting in a probate proceeding. A client of ours named Harry called us in early January 2009, telling us that while he knew he and his wife were covered with a revocable living trust, he had a friend, Charlie. And unfortunately, Charlie just died. The two of them were playing golf with a few others, and when done, Charlie was going home. A few minutes later, someone from the golf course came running back into the clubhouse, urging Harry and his friends to come out to the street. There was Charlie behind the wheel of his car, his foot on the brake, and the car in gear, dead of a heart attack. After discussing things with Harry, we realized that with no wife or no children and no estate plan at all, his sister Patricia in New Jersey was the only heir under the law. Well, we spoke with Patricia and arranged for her to come to North Carolina to get things started on the probate paperwork. A week later, we all sat down with Harry, Patricia, and Charlie's accountant, and we took notes needed to get the paperwork going. She asked for Harry to be the administrator, and then she asked how long it was going to take. I told her that we would try to get everything wrapped up within 6 months, but we could not be sure. Then she said something that stopped all of us in our tracks. Well, what about my parents' estates? They're still open in New Jersey. Well, I sighed and then explained that we would not be able to wrap up Charlie's estate until the parents' estate was wrapped up, since Charlie's estate would be entitled to half of the parents' estate, and from there we could transfer everything to her. Patricia was understandably upset, but she understood. We signed a couple of papers and got the process started, and she went on her way. Now, I can't make up something this tragic. A few weeks after that meeting, Patricia died in a fire at Charlie's apartment. And then suddenly, all of the cousins start coming out of the woodwork. One cousin wanted this account from Charlie's estate, another wanted this asset, another one wanted his car, and I said, whoa, 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 wait a minute. None of you are Charlie's heirs. Patricia's estate is Charlie's heir. If you want to get in line to be an heir of Patricia, then someone should open an estate for Patricia back in New Jersey. Once we receive all of the assets from the parents' estates in New Jersey, we will combine those assets with Charlie's assets, file the appropriate inventories, and then send the assets to the administrator for Patricia's estate in New Jersey. Our estimate was it would be at least a year until the cousins in New Jersey would receive anything. And here's the thing I realized. If everyone in this situation used wills naming the exact same beneficiaries who are going to receive the property, it would take exactly the same amount of time. wills would have done nothing to speed up the process. As tragic as this time frame is, it can be made even longer and more agonizing if the estate is contested, and probate makes it a lot easier to contest an estate versus a revocable living trust. The reason for this is that probate is an ordered process where certain things have to happen before the next phase begins, and all it takes to throw a wrench in the works is for someone to raise their hand and tell the court they're not happy with what's going on. Now, they may win or they may lose, but everything stops until their problem is taken care of. And a lot more often than we would like to think, people get paid to go away. It's not fair, it's not right, but in practical terms, that's what often happens. With a revocable living trust, it's a lot more difficult to contest the trust. Finally, and more importantly with each year, there is a complete loss of privacy for an estate. While there is some variation from state to state, a lot of the main probate rules are the same. Each and every account, asset, and piece of real estate, along with its date of death value, is recorded on an inventory. The names, ages, and addresses of beneficiaries are put into forms, and a copy of the will is filed. All of this is filed with the court, and because it is a court filing, it is completely open to public inspection. A colleague of mine told me a story of how when she goes to do a seminar on revocable living trusts, the afternoon before, she goes to the probate office and copies a file. One time she was giving a seminar and started giving out names, dates of birth, accounts, and the date of death value, and reading out who was receiving property and who was not. A man in the back row stood up and started yelling at her that he knew the woman who passed on and that she had no right to invade her privacy like that. My colleague apologized that he was upset, and then she simply replied that this was the whole point. She had every right to get that information and publicly disclose it because it was part of the probate court's record. So when it comes to wills and estate planning, don't be chained to conventional thinking. I know it sounds like having a last will and testament is the way to go since everyone is doing it, but just because most everyone thought the world was flat didn't mean that Galileo was wrong when he said the earth was a sphere. And so we've reached a point where we can identify that there are problems with probate, and there are three main ways to pass your estate along to your loved ones, with or without probate. That is, other than doing nothing and letting your state rules decide who your loved ones really are. The first is a last will and testament, which is a document most people have heard about. However, most people mistakenly believe that if they have a will, that their estate will not have to go through probate. They are wrong. I get calls all the time from people who said, I was named the executor in my father's will, and I went down to the bank and they won't let me open up his accounts and get the money. Can you write up something called letters testamentary? That's what they're asking for. Well, what they're asking for is for the whole probate court process to get started. Again, if you have a last will and testament, it does not mean that your estate avoids probate. All a will does is names who receives your property after the probate court process is completed. The second way of passing property to loved ones comes with a lot of drawbacks, but if you talk to people who work at a bank or widows or widowers, they'll tell you that joint property with the right of survivorship is all you need. Unfortunately, these are folk remedies that do not work. Joint property works okay for married couples if they do not need to plan for estate taxes, but that does not mean that it is okay for everyone else. The first problem with joint property is there is a federal gift tax. You may have heard this even if it doesn't sound right. You cannot give anyone more than a stated amount of money in any given year. You may have heard $10,000 or $12,000, but the current federal gift tax limit in 2010 is $13,000. For some families where parents or grandparents have a larger estate, they try to reduce their estate each year by giving out checks of $13,000 to each of the family members. The reason it is $13,000 and not any more is because any amount above that is subject to gift taxes, and federal gift tax forms have to be filed. What you may not realize is that every asset that is transformed from an individual's name to two people's names as joint with the right of survivorship is really a gift of half of the asset. While this is perfectly okay between married couples because they have a special tax exemption, it is not okay for a widow or widower to go through their assets and put their child's name on everything that they own as joint with the right of survivorship. This could cause some severe estate tax or capital gains tax problems. They are actually giving half of everything they own to that child. A second problem with joint property is there is actually a tax benefit lost when retitling property this way. While the rules are a little off for 2010, starting in 2011 the estate tax is reactivated, and when a person passes on, all of their assets are valued at fair market value. If there are estate taxes to be paid, then they are paid. The beneficiaries can then turn around and sell the assets at fair market value and not have any capital gains taxes. If assets are half owned by someone else, then that bump up in value is lost for half of the asset, and there are likely to be capital gains taxes. For example, let's say Joe passes on in 2011 and his only asset is a $500,000 stock account that he originally invested with $100,000 in cash. Through his trust, he leaves that account to his daughter, Sue, and there are no estate taxes because his estate was less than the $1 million limit. If Sue sells the stocks for $500,000, then she has no capital gains taxes to pay. If instead Joe put Sue's name on his account as joint with the right of survivorship, then Sue would inherit the account without probate, but now there are capital gains taxes when Sue sells the account. Joe's half of the account is valued at $250,000. The other half has a tax value of $50,000, and then it's also valued at fair market value for $250,000. So that's what Joe originally paid for that half of the stock. So the tax basis is a total of $300,000, and the fair market value is $500,000. So the sale has capital gains taxes on the $200,000 gain. At the 28% tax bracket, that is $56,000 in taxes, or at the 15% tax bracket, it's $30,000 in taxes. And so in order to avoid a few $1,000s in setting up a plan the right way, using the folk remedy of joint property with the right of survivorship costs this estate as much as $56,000 in unnecessary taxes. A third downside of joint property is that putting a person on as a joint owner is a completed gift of half of that account. It's done. Over with. That person owns half of the asset. And if they are named in a lawsuit, then half of that property is on the table. While this didn't happen to one of our clients, an attorney we know in Florida told us about a client who decided not to spend the less than $2,000 to create a revocable living trust, and instead she put her daughter's name as joint owner on all of her assets. Well, the daughter got into a bad car accident. It was her fault. And because of the large court judgment, the daughter had to declare bankruptcy. The daughter got to keep her house, but the extra half interest the daughter had in Mom's condo forced the condo to be sold out from under Mom, and now Mom had to move in with her daughter. While this example uses a car accident as the lawsuit, it is equally true of divorce proceedings as well. The daughter's husband could have just as easily taken the large part of the mom's assets because they were held jointly with the daughter. Now this was never intended, but that could be the case. While I could go on and on about joint property, you might find it more beneficial to read my book, The Joint Property Tax Trap, available at Amazon.com. Now finally, there is the Revocable Living Trust. The best way to understand a revocable living trust is to think of it like a small business corporation. In the corporation, you would be the only officer, the only shareholder, and the only member of the board of directors. That means that even though the company bank account is owned by the corporation, all of the inventory is owned by the corporation, and the store and land itself is owned by the corporation, you still call all of the shots. You're in charge. It's the same thing with the revocable living trust, except it's for your personal assets. You're setting up the trust now while you are alive, and you are the only grantor, meaning the person setting up the trust. You are the only trustee, so you control everything. And you are the only beneficiary, so you are administering this trust for your benefit. And all of this goes the same for couples using a joint trust. The two of them are in charge of everything. But now, all of your assets are owned by the trust, or are set up to automatically transfer to the trust upon death. And remember, since probate is a retitling process, and probate only takes control of assets that were in your individual name, probate now has nothing to control. That's it. You keep control of everything. But at the same time, you're putting a different label on your property, so it is owned by the trust, and it means you're avoiding the probate court process. So shouldn't things be a little easier for your loved ones? Okay, let's recap a little on what a revocable living trust can do. It can avoid the unnecessary costs of probate for all assets in the trust. It can avoid the unnecessary delays of probate for all assets in the trust. It can avoid or impede costly contests of estate plans by avoiding the probate process. It can avoid the loss of privacy that the probate process requires of an estate. And it can allocate and distribute your assets the way you choose, when you choose, under the conditions you choose, all without the probate court's interference. While there is much more that can be said about revocable living trusts, there are already excellent resources out there for learning more. Specifically, there's the book The Living Trust by Henry W. Apps III, considered one of the best books for decades on living trusts, and available on Amazon.com and in many bookstores. There is also my much smaller book, The Anti-Probate Revolution, which is also available on Amazon.com. And if you have already made up your mind to move forward with a revocable living trust, then you can contact my office if you are a North Carolina resident at 919-844-7993, or you can visit us on the web at www.livingtrustlawfirm.com. If you live in any of the other 49 states, you can call the estate plan for a referral at 1-800-350-1234, or you can visit them on the web at theestateplan.com. Thank you for joining us today, and remember to stay safe, plan ahead, and enjoy life.